Hello and welcome. Thank you for joining us for today's Counselor Connect session. My name is Amanda Callahan and I coordinate Counselor Connect, which is a networking and professional learning community for school counselors and social workers across the state of Indiana. Joining me for today's session on the duty to report child abuse and neglect, understanding Indiana laws, is Joel Hand. He's attorney at law. Joel has worked as an attorney for the Indiana Department of Education. I was fortunate to have worked with him several years ago at the DOE. And also he's worked as a prosecutor and a criminal defense attorney. And in all three capacities has worked on cases involving allegations of failure to report abuse and neglect to the Indiana Department of Child Services or law enforcement as required by Indiana law. So you'll hear about that a little bit today, I'm sure. Before we begin, I do want to make you aware that this session will be recorded and posted to our Keep Indiana Learning YouTube channel in the next few days. Additionally, you can access Joel's slides using the bit.ly that you can see here on the screen or the QR code that's also available here on the screen. If you have questions throughout today's presentation, go ahead and add those to the chat, but we will reserve time at the end of the session to answer those questions. We probably won't stop in the middle, but feel free to add those to the chat and we'll get to those at the end of the session. With that, Joel, I am going to go ahead and hand it over to you to get us started.
Okay, there we go. All right, so good morning, everyone. Thank you so much for joining us here today. I'm happy to have the opportunity to present, and thank you, Amanda, for inviting me to do so. We want to do everything we can today to make sure that you don't end up going to jail for essentially doing your job, and so today's presentation is aimed to try to accomplish that goal. If we can get the slide to advance here, maybe. There we go. And as Amanda said, I am an attorney. I'm a founding partner with my law firm of Hand, Ponus, Smith & Rail. I've been practicing since 1995. My law practice currently involves the areas of criminal defense work, juvenile law, education law, professional licensing, administrative law. I also do lobbying work at the State House, hence the reason for the State House screen in the background on behalf of K through 12 public education issues. I am a former chief deputy prosecuting attorney, former director of legislative and governmental relations at Department of Education, also worked as a staff attorney at Department of Education years ago, and at one time was licensed as an Indiana teacher. So our learning objectives today are really four. One, to help you understand who has a duty to report abuse or neglect. Two, when is a report necessary? So what circumstances or factors need to be taken into consideration. Three, to whom must you make the report? And four, what happens if you fail to report? And based upon the title of the presentation, you might be able to guess that answer. So let's first talk about the duty to report. So obligations to report abuse or neglect vary quite a bit from state to state. There are some states that have mandatory reporters that are limited only to certain types of professions or certain types of situations. In many of those states, they will limit mandatory reporting of suspected abuse or neglect to just simply doctors, healthcare workers. Some states will expand that to include counselors, pastors, teachers, childcare workers, or others who have direct or common contact with children. Other states will break it out and list both mandatory and discretionary reporters. And so it would be a list of mandated reporters and then essentially anyone else that would be a discretionary reporter. But Indiana is very different. In fact, we're fairly unique in our state because in Indiana, our statute reads that an individual who has reason to believe that a child is a victim of child abuse or neglect shall make a report as required by this article. So on its face, that seems pretty broad. It doesn't have any specifications for particular types of professions or whether you have regular contact with children or not. And in fact, our statute does not limit the reporting requirement even to those who actually know about the child abuse or neglect. So in other words, you don't have to have firsthand knowledge of the abuse or neglect. It can be circumstantial evidence or information. It can be something you've heard from someone else, hearsay, as we would refer to it in a court of law. Our statute in Indiana does require reporting by anyone who has reason to believe that a child has been abused or neglected. And in fact, in Indiana, it's not even limited to only adults. I think Indiana is very unique in our requirement that it extends even to other children. So if a child has reason to believe that another child is being subjected to abuse or neglect, technically our law requires that child to report that abuse or neglect to proper authorities. So ultimately, who has the duty to report? Classroom teachers, including classroom aides, instructional assistants, substitute teachers, librarians, coaches, volunteers, school counselors, school social workers, school psychologists, school-based therapists, school administrators, principals, assistant principals, deans, superintendents, other school administrators, school nurses, support staff, cafeteria workers, custodians. Truly everyone in the entire state of Indiana has a legal duty to report suspected abuse or neglect. Every single person. You do, I do. Even as an attorney, I'm required to report suspected abuse or neglect. Now, oftentimes I'm asked by clients or other people involved with cases that involve these issues if there isn't an exception for school personnel. And in fact, the law did at one time have an exception for staff members. Under that exception, you could satisfy the requirements of the former statute by making a report to your person in charge at your agency, your school, or your facility. So if you had reported it simply to your principal, your assistant principal, to your superintendent, someone who was designated as having that authority, then under the old law, that would have satisfied your reporting requirement. You didn't have to do anything else. You didn't have to pick up the phone yourself and call the Department of Child Services. You didn't have to call 911. But as of July 1st of 2017, that law changed. Now only hospital staff have that allowance to, or that exception for making that direct report themselves. In a hospital, if you're a nurse, if you're another doctor, if you're a staff member in a hospital and you suspect abuse or neglect, they have that exception that they can report it to a designated person who then is in charge of reporting that information to Department of Child Services or to law enforcement. But that's the only exception that now exists under Indiana law. So who are you going to call? You know that you have that obligation to report. Under Indiana Code 31-33-5-2, it provides that a report may be written or oral, and it may be made either to the Indiana Department of Child Services or to a local law enforcement agency. I've highlighted for you the 1-800 number that the Department of Child Services has that accepts reports of a suspected abuse or neglect 24 hours a day, 7 days a week, 365 days a year. Every single educator, every single person in a school that is working with children should absolutely have that number saved in your cell phone as one of your favorites or one of your one-touch buttons, because you are required to report, and that is the best and easiest way for you to make those reports. The Department of Child Services does allow you to make those reports anonymously. You do not have to identify yourself. So there is some protection there for you if you are concerned about notice going back to a parent about who made a report or what it might entail. Department of Child Services allows that report to be anonymous. Alternatively, you can call 911 or even a non-emergency number for your local law enforcement agency to make that report. But those are the two entities, either one of which will satisfy your reporting requirement. But you must make a report either to the Department of Child Services or to your local law enforcement agency. Absolutely required. So how do you know when to make a report? Suspected abuse or neglect is sometimes hard to discern what you really know and what you think you may know. So let's talk about it and break it down a little bit. First, it has to be for a child, and a child means someone under the age of 18. If you're working in a secondary school and your student is age 18 or older, you do not have a requirement to report the abuse or neglect. You still may report it, but you're not required to report it. I will tell you, if the student is age 18 or older, the Department of Child Services will almost assuredly screen it out because they would no longer have jurisdiction over the student. However, your local law enforcement agency would and could potentially take action depending upon what the information was that you were sharing with them. So the first piece of it that you need to know and understand is that if it's anyone under the age of 18 that you suspect may be subjected to abuse or neglect, that's what satisfies the requirement. So how does Indiana law define child abuse or neglect? Well, under our Indiana code, it refers to acts or omissions by a person against a child, regardless of whether the child needs care, treatment, rehabilitation, or coercive intervention of a court. So that means that just because a child doesn't have to go to the hospital, just because they don't need medical care, don't need psychological care, does not necessarily mean that it isn't abuse or neglect. So I used a couple of double negatives there. I should refrain from that. As long as a child is in some need, even if it does not rise to the level of needing immediate treatment, doesn't have to go to the emergency room, it can still be abuse or neglect. Under Indiana Code 35-46-1-4, neglect of a dependent is a criminal statute. There's an actual charge for neglect of a dependent, and it defines that crime as a person having the care of a dependent, whether assumed, voluntary, or because of a legal obligation, who knowingly or intentionally places the dependent in a situation that endangers the dependent's life or health. 2, abandons or cruelly confines the dependent. 3, deprives the dependent of necessary support. Or 4, deprives the dependent of education as required by law. Under any of those circumstances, that constitutes a level 6 felony for neglect of a dependent. So if you know of a parent, a guardian who is engaged in any of that activity, and you see that show up in some of the students that you're dealing with, the children you're dealing with in your school, that's a mandatory report. You must notify Department of Child Services or law enforcement if one of these elements, or if these elements have been met, that the parent or the guardian has committed one of those acts. But that's not all. Those are not the only forms of abuse or neglect. Situations that can trigger the reporting obligation for abuse or neglect in Indiana are extraordinarily broad. And I'll just list a few of them, but this is by no means an exclusive list. Some examples include if a child's physical or mental condition or health is impaired or endangered because of the parent or guardian or custodian failing to provide the child with necessary food, shelter, clothing, medical care, education, or supervision, similar to that neglect of a dependent statute we just talked about. If the child is, or you suspect them to be, a victim of human or sexual trafficking. That's a pretty obvious report, I would think, but one that needs to be reemphasized, particularly in this day and age when we have so many children that are victims of human trafficking and sexual trafficking. If a child's parent, guardian, or custodian allows the child to participate in an obscene performance or to commit a sex offense, and that could include statutory rape. If you know that that's going on, or you have evidence of that going on, that would be a mandatory report to Department of Child Services or to law enforcement. Now, we also know that not all examples are nearly that egregious. In fact, if you know that a child is the victim of any crime committed by the parent or the guardian, including but not limited to battery, which is striking. Battery is defined under Indiana law as a rude, insolent, or angry touching of another person, it does not have to result in pain, then that constitutes the crime of battery. So if you have a child who's showing up to school, they have bruises, they have unexplained other injuries, that may in fact be evidence of a battery having taken place. Sex crimes, if you know that a child has been molested, if you believe them to be subject to being exploited, or subject to child seduction, sexual battery, sexual misconduct, any of those types of things, those are all mandatory reports. If you believe that the child is become a part of a homicide, either because they have been included within a conspiracy to cover up a homicide, to commit a homicide, or a robbery, a kidnapping, or a confinement, all of those are mandatory reports. But not everything is nearly that egregious. It can truly be any criminal offense in which the child is a victim, or in which the child has been enticed to become a part of that criminal conspiracy, or has become an accomplice by being essentially forced into or enticed into the situation by a parent, a guardian, a custodian, or someone living in the home. This also does include situations where the child is exposed to drug abuse within the home. And unfortunately, we see this all of the time in this day and age, where we know that parents are abusing illegal drugs within the home. The child is exposed to that. Obviously, that can create a severe problem for the child's health and well-being, and that's also a mandatory report. If you know that there's domestic abuse going on within the home, or other criminal activity being engaged in within the home, those are also mandatory reports. The law does not restrict the reporting obligation to people who actually know about the abuse or neglect, and we mentioned this before. If you have a reason to believe that a child is being abused or neglected, or being subjected to any of these things we just talked about, you must make the report, and you must make it immediately. So let's talk about that for just a moment. What does it mean to believe that there's been an abuse or neglect situation? I'll go back a slide here for a second. If you are hearing information from another student, from a sibling, or even from another teacher or a parent, that something has gone on that rises to this level of abuse or neglect, as long as you believe that person, then that is what triggers your responsibility and your duty to make a report. Now, if a child comes into your classroom and they are telling some just farcical story, and you know them by reputation as being someone who just tells a lot of wild tales, that does not necessarily trigger your duty to report, because you didn't believe it. You have to believe it for the report obligation to be triggered. But I will tell you, this is a pretty gray area. And in my mind, as an attorney, when I advise clients, teachers, counselors, whomever, my advice is to err on the side of caution and make a report, and allow those who have that investigatory responsibility to do that investigation. You as the educator, you as the classroom aide, the counselor, the principal, administrator, you do not have an obligation under the law to do an investigation first. And in fact, you shouldn't do an investigation first. It should be as soon as you believe that abuse or neglect to have taken place, that's when you need to make the report. And we'll talk at a little bit later in the presentation about a case where that didn't happen and what the consequences were. But you need to know that as soon as you are of that belief that abuse or neglect has taken place, that's when you must immediately make your report. So what happens if you fail to make a report? Well, if you fail to knowingly make a report on your belief that a child has been the victim of abuse or neglect, that actually constitutes a Class B misdemeanor. That's a crime in the state of Indiana. It's punishable by up to 6 months in jail and up to a $1,000 fine. And it's also important for you to know that it can result in the suspension or revocation of a teacher's license. Now, that is not included within the criminal statute, but because it is a crime under the professional licensing statutes, that can be something the Department of Education could seek to revoke or suspend a teacher's license for. Now, you might say, are they really going to put a teacher in jail? Well, unfortunately, I want to tell you about a case where that in fact did happen. In Smith versus State, which is cited as 668 Northeast 3rd, 668, Indiana Supreme Court, our Indiana Supreme Court upheld a conviction of a high school principal who learned of an alleged rape that took place in the principal's building. The principal and staff first investigated the allegations before making a report to police some 4 hours after the alleged rape took place. Our Supreme Court held that the principal's report was not immediate. And because it was not immediate, that was what allowed the conviction to stand. The court said that it is not the school administrator's responsibility to investigate, that that responsibility is placed firmly with the Department of Child Services and with law enforcement. So I want to flesh this out a little bit, and I have a little background on the situation here with this case. This event occurred in Delaware County. There was a female student who went to an assistant principal and reported that she had been raped in the bathroom at the high school. The assistant principal, quite honestly, at first, is my understanding, didn't believe the student. The student did not have the highest reputation for being truthful. And so the assistant principal made the report then to the principal. They then collectively conducted their own investigation. And then ultimately, after a number of hours of talking to that student, talking to other students in the building, then they eventually made a report to law enforcement of the alleged rape some 4 hours later. Our Supreme Court made it clear that immediate means immediate. And so as soon as the school personnel believed that this child was telling the truth, that there had been a rape, they had an absolute duty to make that report. They did not have any duty, legal duty, to do that investigation first. Now, I will also tell you that one of the factors that I think that the court probably took into strong consideration is the fact that there were police officers within the building. They didn't specifically refer to them in the opinion as school resource officers, but all evidence and indication points to them having been school resource officers, officers who were normally in the building anyway. And while I think that the court could have made that more explicit, I feel pretty strongly that that was taken into consideration, that there were law enforcement officers who could have easily had this information reported to them. They could have then been the ones to undertake that investigation rather than the assistant principal, the principal, and other personnel within the building, non-law enforcement personnel in the building, taking on that duty to investigate the alleged rape on their own before reporting it to law enforcement. So that was the mistake there. You only need to have reason to believe that the child is abused or neglected. And once that you have that reason to believe it, then you must make the report, and you must make it immediately. So we know who we need to make the reports to. We know what we need to report. We know how to make the report. It's critical not to wait, that you need to make that report immediately. I have a lot of times run into counselors, especially, who have had concerns about whether or not they have a duty to keep information confidential. There are confidentiality concerns, particularly for school counselors. However, an exception to that confidentiality is if you believe that a child is being abused or neglected, you still have this legal duty to make a report. I do, however, want to caution all school personnel about privilege. While school counselors have a lot of privilege that prevents them from disclosing or releasing information to other individuals about what a student might tell them. That privilege does not exist for unlicensed social workers. And I know that there are a lot of schools that are presently employing unlicensed social workers in a capacity to work directly with children. In 2016, our Indiana Court of Appeals decided a case, Rogers versus State, found at 60 Northeast 3rd, 256, in which an attorney for a criminal defendant had attempted to, or had deposed or taken a sworn pretrial interview of an employee of a charitable organization who held a degree in social work from an accredited university, but did not have a behavioral health license from the Behavioral Health and Human Services Licensing Board and the Indiana Professional Licensing Agency. The attorney for the organization advised the social worker not to answer questions in the deposition on the grounds that the information that they had collected from the child was subject to privilege for communications between a social worker and a client. They filed a motion to force the social worker to compel and answer those questions, and the court denied the motion. The court gave the defendant permission to file an appeal with the Court of Appeals, and that's what ultimately brought this case to the Court of Appeals. The Court of Appeals then found that Indiana Code 23-25.6-6-1 provides that with some exceptions, a counselor cannot be compelled to disclose communications with a client, and a counselor is defined under Indiana Code 25-23.6-1-3.8 as a social worker, a clinical social worker, a marriage and family therapist, a mental health counselor, an addiction counselor, or a clinical addiction counselor who is licensed under this article. Although this particular decision did not include it, because there is a specific licensure for a school counselor, school counselors would also be included. The question before the Court of Appeals was whether the phrase a licensed social worker, or whether one who is licensed as a social worker has to, is the only one who can have that privilege, or if that privilege extends to unlicensed but yet accredited and degreed social workers. Ultimately, the court found that you have to have a licensure through the state in order for this privilege to apply. So if you have in your buildings people who are unlicensed social workers, they have a degree, but not a license from the state of Indiana, it is important for them to know that they do not maintain that legal privilege that protects them from having to disclose communications of their clients or people that they interview. I also know that there are many schools that employ outside third parties to come in and provide some of these social services to children and to students. Occasionally, I hear of cases where the school might refer to them as a counselor or a social worker, even though they don't even possess a school counselor degree, they don't possess a school counselor license, or they don't possess a social worker license. This privilege under Indiana law will not extend to them either. So if you're an administrator listening to or participating in this continuing education program, it is really important that you stress to your employees that are not licensed that they do not have this privilege, and they can be forced to reveal those communications with their client, quote unquote clients, or the students that they would interact with. And I think that's a very important distinction to be made. So at this point, I will open it up for some questions. If anyone would like to ask any questions, I saw that there was at least something here in the chat, but I didn't look to see. Okay.
Can you see that, Joel?
I can. I just pulled it up here. It looks like there's a question from Ashley. The question says, when a parent or guardian shares with a school staff member that the student has been abused and they have reported to DCS already, what is the staff member's duty? This is an excellent question. Do you still have to make the report because you believe something is happening from what was shared with them? From my experience, DCS can't confirm that a report has been made, so it would just need to be a new report. So if I were representing you as your attorney, my advice to you would be make the report. However, there is an exception if you have reason to believe that a report has already been made, then you do not need to make a report. Now, normally I would say, if I'm advising a client, if you're hearing from a non-school person that they have made the report, I'm not sure how much credibility I would put behind that if you're just hearing it from another adult outside of the building or a parent. If it's one of your staff members, if it is your principal, if it is a school counselor, a teacher, and they've told you that they've already made the report, I would like to think you could probably rely upon that. But that is about the only thing that will eliminate that trigger of the mandatory reporting. So again, I would say that the best advice I can give you is that if you're hearing this from someone outside, if you're hearing it from a parent, a guardian, or even some other adult outside of the school setting, it's probably best to go ahead and make the report. You're always better to err on that side of caution. Let DCS screen it out. Let them be the ones to figure out that they've already received the report if you truly believe it. So let's see here. There's another question. Okay, just to confirm, reporting to your school administrator does not meet the requirement to report. Yes, that is absolutely true. If you report it to your school administrator, you report it to a dean, an assistant principal, whomever, that does not satisfy your statutory obligation. You still have to make the report yourself. So just out of full disclosure, my wife is an elementary school counselor, and I think she hears about these situations sometimes hours later or days later, where an incident has occurred in her school, in a classroom, and then the teacher comes to her and says, oh, hey, this happened. Well, my wife at that point has a duty to report immediately, but that classroom teacher who didn't make the report immediately could very well find themselves in trouble because they didn't make the report immediately. So every teacher in your building, every cafeteria worker, every custodian, every secretary, every single adult in the building needs to know that as soon as they have reason to believe that there is abuse or neglect of a child, they individually have that absolute legal obligation to make a report. They cannot satisfy their legal obligation by coming and telling the principal, by coming and telling a counselor, a dean, or anyone else. They have to make the report themselves. Of course, now, if they do make the report to you and you are the dean or the counselor or the other teacher, you now have a duty to report too if you believe that this other person has not already made a report. So that would then trigger your duty to report. Okay, it looks like there's another. How does this apply to clergy within a school? So clergy within a school are still mandatory reporters. Again, every person in the state of Indiana is a mandatory reporter, regardless of their age, regardless of their profession. Clergy do have some privilege, but again, that privilege does not include withholding information about abuse or neglect. If you're a clergy member and you believe that a child is being abused or neglected, you still have a statutory obligation to make a report to Department of Child Services or to law enforcement. The next question I see here, do I have guidance on maintaining confidentiality as a licensed school social worker as to where to best keep personnel case notes? If I keep my personal case notes on my password protected drive on the school's computer, are they allowed to access it, or should I use a personal drive to keep those notes? You know, that's an interesting question. It probably goes a bit beyond the scope of this intended presentation. I would say that if it is something that is able to be accessed by other school personnel, then it's no longer confidential. You have broken the confidentiality. So confidentiality, as a general rule, is only going to exist between you and one other individual. Confidentiality is broken as soon as there is any third person that is introduced to the mix, unless that third person also has a duty of confidentiality. So in other words, if you have a licensed social worker and a school counselor who are both meeting with a client at the same time, each of those adults has a duty of confidentiality to the child. So there could be that sharing of information between those two without it breaking confidentiality. But as soon as it is shared with or has access to somebody who doesn't have that protection of confidentiality, then the information itself is no longer confidential. So if you are keeping hard copy records, then it's going to need to be probably kept in a locked, safe place where no one else has access to it. If it's on a digital format, I think my advice is to keep it in a format that it is password protected and only you have access to it, and no one else can gain access to it. I hope that that answers the question. Oops, next question, which I just skipped past here. Will we as a counselor get in trouble if we reveal too much of our private notes to DCS and or administration? Or is it better in the case of safety and a threat to reveal it? Really, this is very much case by case. You are required to make the report of abuse or neglect. When you make that report of abuse or neglect, you're going to need to share enough information to share with the Department of Child Services or with law enforcement why it is you had the reason to believe that there's abuse or neglect taking place. If you go beyond what was necessary for you to then believe it, you, I suppose, could be in running into some difficulties with your duty to confidentiality. But if I'm your attorney, my advice is that I'd much rather have you err on the side of providing Department of Child Services or police in making sure you're providing them with enough information to validate your concerns for there being abuse or neglect, rather than the confidentiality. I think that because confidentiality is a civil remedy, if I'm in your shoes, I would much rather take my chances with a civil judgment against me as opposed to potentially facing jail time and or fines and having a criminal record. But that's my answer at first blush on that question. The next question here, a school personnel has an MSW, but has not applied for a state license. Does the DOE have a state license like some have for a licensed professional school counselor? I will just say not that I am aware of. I have not looked to see if the Department of Education has a license. That was not a part of my preparation for today. I suppose maybe I should have. The way that I read the case, the 2016 case, though, is that there would have to be a license from the Indiana Professional Licensing Agency and the Behavioral Health and Human Services Licensing Board. Now, if there is a Department of Education license, that may be able to take the place of that, but I would have to look at that and see if that even exists.
Joel, I just put in the chat that the DOE does have a school social work license.
Okay. Do you know, Amanda, when that came into place?
It's been for as long as I was at the department. So,
okay. So that's
at least 15 years, I'd say.
Okay, so it's going to predate that case from 2016. Obviously, with the case in 2016, they weren't talking about a school licensed social worker because that was not a part of the fact pattern there, and they typically will just stick to the fact pattern they're presented with. I don't believe that there have been any cases directly on point for that we have discussed that school licensed social worker, but it would give me some pause for concern, to be sure, about whether or not that privilege was going to extend to those individuals. Now, again, that's a civil remedy, not a criminal remedy. But I think that it does raise a good question, and one that's worth some additional thought and consideration, and probably some additional research.
I think oftentimes, and if there's a school social worker on the line, correct me if I'm wrong, but I think a lot of the time school social workers get kind of that dual license. So they apply for the DOE license and also the license through the professional association as well. Or
yeah. If they have that, then they're definitely going to be covered. I guess the question is going to be then in my mind as to whether or not the license issued by the Department of Education will suffice for them. My assumption is that it probably does, but that's purely an assumption. And at first blush, I've done no research to verify that.
I am a licensed school social worker, and I had to get my license through the state before I could do it through the DOE. So I had the two-step process with that.
Thank you.
Thank you. And that Keaton, was that you that
Yes.
made that comment?
Yep.
Okay. For my own edification and everyone else's, was that requirement put into place by your school corporation, or was that by the Department of Education?
No, I believe through the DOE. During my schooling, I went to school, my master's program in Indiana, and it was stressed to us that as soon as we graduate with our MSW, we're now able to sit for our state licensure. And then as soon as we pass our state licensure, you submit that license to the DOE, and they give you your school social work license.
Okay, good. Thank you for that information. That's helpful. The next question posted here in the chat: do you have any experience or past cases with educational neglect? Yes, I've had a number of them in both a prosecutorial and a criminal defense capacity. We often hear times of parents who withdraw kids to homeschool but have reason to believe they are not being educated. This may be a question that's better for DCS, but just curious. Well, if you have a situation like that, where you believe that a child has been withdrawn to quote unquote homeschool, and I don't mean to disparage those homeschoolers that are actually doing the job of homeschooling their children. I am sure and 100% confident that there are some parents that do an outstanding job of educating their children in a homeschool setting. But I think all of us who have been involved with K through 12 education know and have seen examples of parents who will say that they're homeschooling their child and they're really doing absolutely nothing to provide that education. Under the neglect of a dependent statute, you may recall there is a provision for educational neglect. And so if you have reason to believe that a parent is engaging in that educational neglect, that is a mandatory report. So you can just imagine the situation in your own mind. You have a child who's been having some difficulty in school. Maybe it's behavioral problems, academic problems, what have you. Parents get frustrated. Parents themselves, again, this is a hypothetical situation, but let's just say that maybe they don't have a very high educational level themselves. You are concerned that they don't have the capacity to provide an education through homeschooling to their child, or financial means to be able to do so. And then you see some other further evidence of that to verify your concerns and to cause you to have this belief that the child is not being educated. That's a mandatory report under the statute. So I hope that that helps answer that question. All right, looks like we have some more questions here. Well, the state does have a school social work license. That was a comment made earlier. Yes, thank you. All right, next question. If we are notified of abuse or neglect, that happened years prior, but not necessarily happening currently, what is our obligation to report? Excellent question. You will notice that in the materials I provided on the slides, and if you go back and look at the statute yourself, there is no time period or time period limitation on the statute. However, it does seem to be in the present tense. So if you are notified that there was abuse or neglect that took place in the past years prior, I would suppose if you are 100% confident that, well, actually, I think I'm going to change my opinion on that. I still think you're going to have that duty to report as long as you have no reason to believe that it's previously been reported, either to law enforcement or Department of Child Services. So, classic example that I can think of off the top of my head is a child comes to you as the trusted adult and says that they were molested when they were a child. Well, molestation, there's a long look back period for that. And the statute of limitations is very lengthy. So if a child comes to you and says that they were molested when they were 5 or 6 years old, and now they're a high school sophomore or junior, I think you still have that duty to report under the statute. Anyone want to ask any follow-up questions to the questions that I've already answered? Wow, we really flew through those materials much faster than I thought we were going to get through them today. But you asked some absolutely fantastic questions, and I appreciate that. I can't emphasize enough how important it is to make those reports. Do not wait. Do not feel like you can push it off onto someone else. And I think that that's probably the most common mistake I've seen and heard about from my clients, is that they feel like they can overcome that obligation by making that report to a principal, a dean, or someone else within the building. And that is just simply not the case. In fact, I mean, going back to that Muncie situation, I am quite honestly shocked that more educators were not charged in that case, because there were definitely more people in the building that were involved in that investigation, that had opportunities well before the 4-hour mark to come to that belief that that student had been raped. And I think that in that case, the prosecutor's office recognized that it was a case of first impression, and they wanted to make a statement by charging the highest level person within the building that had knowledge, because it would make more of an impact, not only there in their local community, but probably across the state. But truly, knowing more of the facts of that situation, the assistant principal, other educators, other people in the building that were involved were very, very fortunate not to get charged. I think based upon the fact pattern that we had and the conviction that ended up being upheld by the Supreme Court, convictions could have been upheld against many other people as well. So please keep that in mind. I do not want to have to receive a call from any of you saying, Joel, I'm been charged with failing to make a report. Can you defend me? It's not that I don't want your business. I just don't want to see you facing that type of trouble. So please, please, please make sure that you do make those reports. Someone posted on here, in most cases, I do contact the parents. So if you're contacting the parents about something that the parents have done, or that you believe the parents have done, you may be interfering with unintentionally the Department of Child Services or law enforcement investigation. I would be cautious about doing that. You also don't want to put yourself in a situation where it appears that you're attempting to conduct an investigation yourself, because remember, that is not your obligation under the law. Your obligation is to make the report once you believe that there has been abuse or neglect. So I'm not telling you you can't contact the parents, but you have to be really cautious that you're not making that your first call. Your first call has to be to Department of Child Services or to law enforcement.
And Joel, there was the question was asked about a couple of comments above in the chat.
Oh.
Do we have an obligation to call parents?
Sorry, I missed that one.
It sounds like the answer to that is no.
No, you do not have an obligation to call the parents, not under these reporting statutes. Department of Child Services, they ask you if you've contacted the parent. Well, a part of the reason why they might be asking that is to figure out if that part of their investigation has been compromised. Having been a prosecutor and having worked with Department of Child Services in that capacity, they're always concerned what a prospective witness may know before they go out and do their own investigation, and whether that investigation could have been compromised because information was shared by an outside source with that person before they go out and do their interview. So that's probably why they're asking that question, not necessarily that they're encouraging you to contact the parent first. They're just trying to find out whether or not they need to alert their investigator who gets assigned that the parent may have been tipped off because there was already contact made. Yeah, it depends on each situation. Well, certainly, and there's sometimes you may feel like you have to contact the parent if the parent is not the one you're suspecting of the abuse or neglect. If it's, say a third party, and you don't necessarily believe the student who's made the report to you, or you're not sure. So, let's say you see a child come to school and they've got a mark or a bruise or something like that on them. The child doesn't really have an explanation for how the mark got there, but it looks like to you that it's not because they just simply fell down or bumped into something. If you decide to call the parent, I'm not sure that it's unwarranted there. It may be worth your time to call. It may also be better off for you as a classroom teacher to turn that over to someone in the building to make that call rather than yourself, because as soon as you make that call to the parent, if they do have something to hide, they're probably not going to tell you about it, number one, and number two, you're going to be putting yourself in a situation where you've then tipped the parent off. These are all very fact-sensitive situations. You have to be extraordinarily careful about failing to make reports when a report is required.
Joel, I received a direct question in the chat. Online K-12 schools, when we do not have daily contact with students or we don't see them to possibly see evidence of abuse or neglect, are we still held responsible for not reporting something if nothing was seen, quote unquote, per se, versus learning information during a phone call or a Zoom session with a student?
So the key element there is that you have to have reason to believe that there's been abuse or neglect. The statute does not require that you have visual confirmation of that reason to believe. And knowing whether or not you have a reason to believe it is something that's very internal to you. When I may see a situation and I may think that I have reason to believe that there's been abuse or neglect, and another person may look at it and not feel like they have reason to believe that, just based upon our different experience, our different human experiences and our backgrounds. But if you feel like you have reason to believe that there's been an abuse or neglect, you still have that duty to report, even if you don't have that visual confirmation of it. So if you have that relationship with a student to where they've told you something and you have no reason to disbelieve it, and you think that it's true, then you've got that obligation to report. That obligation is going to trigger for you. Okay, I don't think I have any more questions in the chat.
Okay, well, thank you so much, Joel, for presenting today. That was really helpful. A few things as we wrap up the session today. I did link into the chat an evaluation form. It is also the form to request PGP points or CEUs for those of you who are active members of INSWA. So go ahead and please fill that out. That's really helpful information for us for future sessions as well. Do want to also share that this will be recorded. I will send you all the recording link. It will also be posted to the Keep Indiana Learning YouTube channel, so you can check that out. It'll probably be posted sometime next week, I would guess. Next, I want to share some upcoming events that we have on the screen here. We have some some intensive year-long series that are happening, including Restorative Practices Readiness for School Leaders. This is with Allie Hearn. It will be all virtual and it will kick off September 26th. Therefore, registration for this actually closes the 16th, which I think is Friday of this week. So if you're interested in this one, please be sure to register in the next day or two. School Counselors for MTSS, this will launch in January, and it is being presented by Dr. Emily Goodman Scott and team. They are nationally known presenters and are amazing. So check that out. And then we just posted registration for the Comprehensive School Counseling Institute, which will be a hybrid training starting in October. And that one is free. So if you're interested in meeting requirements for the Indiana's Carrying the Torch, or if you are re-ramping, then be sure to take a look at this one. Monthly sessions, mostly free, that are coming up. You'll also see those on the slide. We have a live stream, the importance of college and career advising, that is happening on the 21st of this month. And then some other events there. The Counselor Connections event on September 22nd is in person in Indianapolis. So if you want to join us for that, then take a look at the registration for that and register very soon. That is next week. Contact information is here on the slide. Be sure to subscribe to our monthly newsletter if you want to stay up to date on new events and resources that are shared. And with that, I am going to close our session. Thank you for joining us again. Reach out with any questions and be sure to fill out that evaluation form. Thank you very much and have a wonderful rest of your day.
Thank you, everyone, for attending. It was a pleasure, and I was honored to be here. Thank you for all the work that you do every day for our students. I truly appreciate it.
Thank you, Joel.